Amber Cohen here at Her Legal Lenz, and just we are going to be capturing the closing arguments for Commonwealth v. Kelsey Fitzsimmons. And closing arguments are where we get to hear from the attorneys, where they wrap all the evidence into the argument to present to the court what they think happened, what their side thinks happens. So Attorney Bradel will present, presumably for Kelsey Fitzsimmons, and then the Commonwealth will close out. Really, I'm going to hopefully be able to walk this through live with you to witness what I suspect will be strong closing arguments on both sides for Judge Karp to consider his decision. I believe Judge Karp will be coming out, he said, off the bench, and then presenting presumably his decision at 2 o'clock this afternoon. And so we will wait to see what happens there. I am just trying to see if they have not come live yet. So we are waiting for the court to come on, and this is exciting. I am very nervous for the parties. I'm sure the defendant is extremely nervous waiting for this closing, although honestly, she might be feeling some sense of relief and peace after she was able to really tell her story yesterday on the stand and be able to share that with the public. Most of the time, while these cases are ongoing, defendants are advised not to speak publicly about the case. They're advised to, remain quiet while the case is ongoing, allowing the attorney to do his or her job to figuring out what the evidence is, how this case is going to proceed. And so presumably Kelsey has not been able to publicly share or speak about what's been going on or what is going on in her side of the story. So she's had to remain, fairly quiet, I think, during the time, even though this has been a high media profile case. I think the attorneys have been doing most of the talking for her. So let me just see here. We are waiting for them. And again, just to recap yesterday, a little bit about what we heard with the defense strategy and what they are presenting, which is clearly no intent, that this is a no intent case, so that this prosecution should fail because they believe that probably the prosecution has not been able to prove beyond a reasonable doubt that the shooter, that Kelsey lifted her gun with an intent to hurt Officer Noonan. And so the case is going to come down whether or not the defense was able to sort of shift, and whether the judge believes that the Commonwealth was not able to prove beyond a reasonable doubt this evidence. So this is, interesting, and I think what makes it so incredibly interesting for someone like myself or the media is it intertwines a lot of subject matters that a lot of people deal with on the daily, frankly. I mean, we're dealing with a custody dispute, we're dealing with mental health issues. It is a little bit alarming to see the officer-involved shooting. We have a veteran officer on one side, we have a rookie officer on the other side, a young mom. It involves potentially, we didn't hear any testimony about postpartum, but I know that has been some of the, media draw to it, is whether or not that was an issue. And so, so there's a lot to think about and a lot to discuss, and I am learning how to moderate when we are waiting for court to come. So this is interesting. Just for everyone that's new to our channel, Attorney Sanders, who is normally my co-host, is out this week. She's on respite, and I don't, we're not we're not asking her to film from her location while on vacation. So I am here battling it out myself on this trial, which I'm also trying to learn new tricks of the trade and teaching myself some new technology skills. As you can see, I'm flipping back and forth, and this has been very exciting for me this week. But it's also, it is interesting, just as an attorney in technology in the courtroom. I do think that this blogging has allowed me to learn more. I've always thought that maybe I've had some technological advances above some attorneys. Not all. There's a lot of attorneys that are very technically skilled, but this has helped me to understand just some other video editing and that sort of thing, although this is not being edited. This is live. So pardon me for every and which I have realized that I say quite a bit more than I would have liked or thought. I just did it again. One of the appeals for this case is the emotion versus sort of legal precision. So I think that's one of the things why this defense team and why Kelsey ended up picking a judge to go and make this decision on her behalf, is because when you've got some emotion in the case, the judge is able to consider that. I think that you've got two sides, emotional on both sides, and the judge will be able to really narrow the issue and hopefully see, based on the facts and the law, what happened. So we are reminded that the burden of proof, the closings will most likely have that in there, but obviously the judge knows the law. The burden of proof is beyond a reasonable doubt, which whether or not the Commonwealth has met that is going to be determined by Judge Karp. Judge Karp has been through this trial. You can see he's very thoughtful. He's extremely considerate to both sides. He's listened to both sides. He has sustained both sides. He's overruled both sides. And I would consider that, a very fair judge. The role of being a judge is basically, to give you sort of a analogy, is like an umpire in a baseball game. It's calling balls and strikes, right? Letting the evidence in as the judge sees it, based on the rules of evidence. And that can be a really challenging decision to make in the moment. Sometimes we see judges say, I'm going to need 5 minutes to look at that. We did just see in the Corey Richens trial that Judge M had to take some breaks. He did some research, came back with case law, made his rulings. I think Judge Karp has done that here with a couple of decisions. So it looks like we are going live here soon. The screen has moved to the courtroom. And while we're here, I might as well plug Her Legal Lenz. If you like what you see or hear or want to follow our content, if you would like and subscribe, I would be grateful for that. We are building our channel. This is a dream that I sort of thought about, I don't know, a year or two ago. Oh, they're coming in. The courtroom's coming in. But anyway, like and subscribe if you do, please. Judge Karp is entering the courtroom.
All persons have entered the court before the Honorable Jeff Karp, Justice of the Superior Court. Now sit in honor stand before the County of Essex. You are here, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, and this is the honor of the court. Court is now open. Please be seated. Good morning.
March 26, 2026, Court 2, Lawrence, Superior Court. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311. Scheduled today for continued jury waive trial. Could counsel will please identify themselves for the record.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons.
Good morning. Good morning, Mr. Fitzsimmons.
Good morning, Your Honor. Bradle. With me is Ms. Healy, Ms. Hassan, Mr. Leonard. Good morning.
Good morning. Thanks. You have a seat. All right, so you folks ready to proceed?
Yes, sir.
All right, I don't say this for the attorneys who know this, but because the government prosecution has the burden, they go last. The defense goes first in their closing. And Ms. Bradle, you may proceed.
Thank you very much, Your Honor. May it please the court. Counsel, ladies and gentlemen, Your Honor, June 30th, 2025 was the worst day in Kelsey Fitzsimmons' life. Her whole world imploded. Her fiance betrayed her. Her baby was being taken away. She was going to lose her house, her job. It was an incredible confluence of tragedy that was visited upon her that day. That day was about her, and she decided in the midst of what you saw testified to here, she decided to end her life. Patrick Noonan, when he came back up those stairs, Your Honor, walked into a suicide in progress. That gun was nowhere near him. That gun was already pointed at Ms. Fitzsimmons' temple by Ms. Fitzsimmons. She was a couple steps into the room. Officer Noonan, a gung-ho cop, highly trained, a SWAT guy, he'd already been ginned up all afternoon by the insane, ludicrous statements of Justin Elaine. He had that in his head. He walked in, and like all of us are susceptible to, he made a mistake. He shot too quick. He reacted too quickly. And instantly, he realized that he had to adjust the narrative. And that was easy, to just add 6 words to the equation, Your Honor. He said, words to the effect, she pointed the gun at me. 6 words. What did those words do at that time period? Those words made him the victim. Those words made him the hero. And those words, most important, made him untouchable. Those words were a defense for his future, his life, his reputation, and they were conveyed to a very willing audience. His colleagues, his brothers, his family, the investigators on the case. So that's really what happened here, Your Honor, and it is a tragedy, and it is something that should not result in any further harm to Ms. Fitzsimmons. This should be over. This should be an acquittal, Your Honor. I want to talk to you about a few of the elements that I know you're going to be concerned about. So, first thing I want to talk about, Judge, is the lack of motive and the lack of intent. Because when it gets down to brass tacks, I know that you're going to look at the law, you're going to look at the credibility determinations, and you're going to make a judgment. And here, this case fails. The Commonwealth ship founders on the rocks of lack of motive and lack of intent. Let's talk about motive. Everything in life is motive. And it's ironic that, us lawyers always say, oh, you don't need to prove motive. But you really kind of do. It might not be an element of the crime, but motive is everything in this business, Your Honor. Let's look at the motive or lack of motive. Fitzsimmons and Noonan are colleagues. They have already bonded over shared tragedies, shared experiences. They were okay with each other. They were friends. Kelsey thought well of him, and she thought thought well of her. She knows he has a family. She knows who his family is. She's not going to harm this guy. She knows, Your Honor, that he didn't do this to her. She knows that Justin Elaine did this to her. And she's, probably most important, she's been in those shoes before, serving restraining orders. She knows she's just a messenger. She knows he's just a messenger. This was the worst moment of her life, and she wanted to end her life. And how did she want to do it? She wanted to do it alone. She didn't want to involve these officers because she knew this was a selfish act. She came in here, and ironically, the most credible evidence that came into this case, Your Honor, was from the one person that didn't have to testify. And she came in here and she chose to testify. And she waived her rights and she testified. And she showed, Your Honor, that she's a moral person. She's a caring person. You'll sit down and you'll deliberate, and you'll be drawing the inevitable conclusion that Kelsey Fitzsimmons is a moral person. You have to contrast that with the callous treatment of this case from the other side. Hey, we're going to go serve an order on Kelsey Fitzsimmons. Her ex-fiancé got an order on her, on Kelsey. Let's go serve an order. The answer, sounds good. Let's go. Talks to his neighbor. Oh yeah, I'm the shooter. I'm the shooter. She's a whack job. So you have to take these credibility determinations into account. And I know you're a gentleman, but you have to get down to brass tacks on who's who here. What else shows you that she's a moral person? She doesn't want to involve these guys. She's trying to get rid of them. She says, oh, the guns are over here, so she can go where they really are. She keeps trying to give Houston and Noonan baby things to bring downstairs. She's trying to get rid of them. She's trying to get them away from her. She wants to do this on her own. She doesn't want to have some sort of situation where she gets shot by one of her colleagues and friends. It's understandable because she's a moral person. She waits for her chance. She gets to her room. There's a distraction downstairs. She doesn't know what's going on because she's focused on the job she's trying to do here. The tragic, awful thing that she's trying to do to herself. That's how you know she's telling the truth, Your Honor. You saw in the room, and I'll show it to you in a minute, the chest that she got the gun from, it's a chest on the floor. It has one of those pretty substantial lids that you have to flip up to get the gun, locate the gun, pick the gun out of the 4 guns, and stand up. If Noonan was standing right there in the door frame, that would have never happened. All those events, that little series of events, he would have been able to stop it. He would have stopped it. It tells you that he's down the steps. He was interested in the distraction downstairs. He saw Kelsey folding some baby clothes, getting baby things ready. His attention, it's human nature. His attention was drawn to go back down the stairs. He walked down the stairs 2 or 3 steps, 4 steps, whatever. And Kelsey told you, straight up, that was my chance. And she took it. And she went in the chest, zip 51, Your Honor, I'll show you right now. She went in that chest, flipped up that lid, got the gun, stood up. She told you again, she's a moral person. She tried to keep the gun concealed. She made the motion like this, Your Honor, where she put the gun like this and she kind of walked over here. But she didn't want the police to see her with a gun. She held the gun to her stomach area. She walked to a clear area and she put the gun to her head. And that's what I mean when I say Officer Noonan came back up the stairs, and what did he walk into? He didn't walk into some Rambo woman trying to shoot him in the face. He walked into Kelsey, who you now know a little bit from her testimony. He walked into Kelsey's room, and Kelsey had a gun to her head, and he walked into a suicide in progress room. And the man had just been holding her baby, that she chose to hold her baby, that she chose to feed her baby, walked into her suicide in progress. The gun was nowhere near Noonan. There was no threat to Noonan. And the law says that an officer may not use deadly force on someone who is exhibiting a danger only to themselves. And that's offered to Your Honor twofold, in the sense that it shows that this was not a reasonable use of force, and it shows you that his knowledge of that statute, as he said on the stand, gives him a motive to lie. He knows that this is not a good shooting. He knows this is not a clean shooting. And that gives him a motive here, Your Honor. And like all of us, we all make mistakes. He overreacted and he shot. He had the look on his face, panic, flustered, he shot. He had made a mistake by leaving her there, walked down the steps, a few steps, and that gave her the chance. And when he did this, he knew immediately, Your Honor, that he had to adjust the narrative. Filtered through the legal lens, Your Honor, that tells us that Kelsey had no intent. She had no intent to harm him. There's no assault here because she didn't have the intent to do so. As the fact finder, you can consider everything you said about motive, that she lacked any motive to harm this gentleman. In fact, it was the opposite. She thought well of him. She knew Justin did this to her. She had just trusted him with her baby, and she had tried several times to get these officers away from the situation. No intent to harm him, no motive driving her mindset to do so. Reasonable doubt, burden of proof, Your Honor. Where the evidence supports a reasonable and more plausible alternative, and that's shown here by Kelsey's testimony. It cannot be said that Commonwealth has proven the case beyond a reasonable doubt. There is reasonable doubt when there are two plausible versions of what happened. That itself is reasonable doubt. The versions themselves, Your Honor, show reasonable doubt. Kelsey's version rings true. Noonan's version is all over the place. Noonan's version is contradicted by the strong consensus of everybody else in the house. Noonan portrays a couple different stories, but if you want to pick one where it's this drawn-out potential gun battle, where she's backpedaling, sidestepping, tapping, racking, there's commands going on, that takes time. It takes time for me even to say it. Never mind do it. And that's belied by everything everybody else in the house says. Everyone else says, Kelsey, no, 2 shots in quick succession, bam, bam. That does not fit with what Newman said happened. So, on that alone, Your Honor, as a fact finder, I suggest that your duty is accomplished quickly, because there are two extremely divergent versions of this event. And Newman's version has changed itself. Newman's version is inconsistent with who you now know Kelsey is as a person. It's self-serving. And like I said, it makes him untouchable. And when you judge it against house, he's the only one with the Rambo story. Everyone else has what Kelsey says. He walks into a suicide in progress, he sees it, he reacts, Kelsey no, bam bam. Brain freeze, mistake. Has to cover it up immediately. What else do we have? You know, when you're a fact finder, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. You know, the big one, the big elephant in the room is that this department has no body cameras. We wouldn't even be here if they had body cameras. There's no evidence other than people's words. He said versus she said. That's oftentimes, almost all the time, not a good place to start for the Commonwealth. How many of these guys didn't do reports? What's up with that? Why didn't Trooper Strong put the body camera video on the witness he's interviewing? There's no science. The testimony of everyone else in the house shatters his narrative. Kelsey Fitzsimmons has been blessed. She should be dead 2 times over. By her own hand and by the hand of Officer Noonan, who shot her. She's blessed. She's here today, and she has a new lease on life. Maybe that's why the investigation is what it is. And maybe that's why the story is so sloppy, because nobody expected her to be here today and tell her truth. But she is human. And as a fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies. The credibility contest is firmly in her camp. She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Mark.
Thank you, Mr. Witt. Comment? Yeah, just a minute. Yeah.
I mean,
Yes.
every piece of credible evidence in this case proves one thing, that she's guilty. All the testimony, the scientific evidence, the physical evidence, the demonstrative evidence, everything points to one conclusion: she is guilty. Even her own testimony proves she's guilty. Because it's impossible to have happened the way she said it. It is scientifically, mechanically impossible for it to happen the way she said it. Her story is that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too. She pulled the trigger, gun? He found that black box, the safe. He made sure that was empty. He turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in it. And then they stood watch on that until State Trooper Bonassaro took it back in the lab. That magazine that you have in evidence contained 16 rounds. It was a 17-round capacity gun. It contained 16 rounds, plus the one that was in the chamber. 17 rounds. As we know, there are only two ways to get a bullet into the chamber. One is if there's already a bullet in the chamber. Someone pulls the trigger. A bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come out. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber, other than that way, is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun. What did Officer Noonan say? She pulled the trigger. Nothing happened. She stepped back, tap racked, tried again, didn't do it. Tap racked again, pulled it, and that's when he fired. She put a round in that chamber. That's the only way it got there. Her story can't be true. She got up on that stand and she lied to you. It's scientifically and physically impossible for her story to have happened the way she said. That's what the evidence shows. But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself. But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her. Because she's losing her life, her job, her son is being taken away, all of these things. And so she's going that over her head. And then minutes later, as she's walking through the house, she says, my gun's in the basement. Because that's the time she made the decision to kill herself. Later on. And we know that's a lie. We know that's a lie because what was one of the first things they asked her when they went to that house? They asked her to put the baby down because they were concerned for the baby, told her the restraining order, what the parameters were, and asked where your guns are. When she was still sitting on the sofa. They weren't waiting to ask that question so she was already walking around the house. No way. And what did she say there? They're in the basement. And we know she said it there before she moved around the house, which is untrue. Because her friend, Officer Houston, who was invited to her wedding, says it also. He says, Sergeant Daly asked. And then remember what he said? He said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa. And so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that point did she say that? We don't know. She didn't tell us, because she lied to us about why she said it later, because we know she didn't say it later. So she lied again. You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officer, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house. And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant. She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house. She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else she lied about? Something so simple, but it shows who she is. The restraining order. She said, the restraining order was taking my dog away. It says it. It doesn't say that. Nothing about the dog in there. I could go on about the lies, but I want to talk about the credible evidence. The credible evidence in this case. When Lieutenant Daly got a call, actually got a visit from Justin Elaine when he was in the lobby of the PD. And Justin told him he got into an IA against Kelsey Fitzsimmons. And Detective Daly knew that she had been sectioned before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daly, we've got to do this. And so he wants you to believe, defense counsel, that Pat Noonan was cavalier about, oh, okay, sounds good, we have to serve a restraining order. But that's not what happened. He was mischaracterizing it, and I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order, can you meet me by the school? Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daly was there that they learned really what they were going to do. And they went over there. And defense counsel asked Daly, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daly said, no. No. His quote was, we had an increased level of vigilance. Everyone was more on point because they did know what they were walking into. They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away. This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daly, I'm worried she's going to kill the baby, kill herself, and kill someone else. So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least two of them, while she did that. And you know that because even Officer Houston said, I was in her pocket. And we went into the kitchen, and I noticed there were butcher blocks with knives on it, with knives in it. And they were concerned. There was no chance they were leaving her alone. No chance they were leaving her alone. Officer Noonan. Officer Noonan. All of the testimony that you heard about school security forces squadron with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons, shoot, no shoot scenarios, twice a month, and a 40-hour block every year. For over a decade he did that. And he moved to Lawrence, as far as the department goes, because it was busier, and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say when they're upstairs and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to is a joke. It really is. Now, how do you know they were going by the book at that point? And how do you know they were villages? Because they followed around everywhere. Because both Houston and Officer Newman said she kept handing us things, and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping nothing did, but ready for whatever happened. So at some point, Houston and Noonan are upstairs, and the defendant goes into her room. And she hears Justin, and Houston goes down to keep the peace to make sure he's there. And Officer Noonan is watching her. He's watching her. And she's on one knee, and she lunges, and she disappears. And she emerges with this, pointing at him like she is trained to do. Click at his face. And what does he see next? He draws his weapon, and he says, this testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on him. And why did she do this? Who knows? Maybe he's right. Maybe she was going through him to get to justice. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, she started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she flipped? She stepped back, and now he knows, based on his training experience and the clip, there is one round in the chamber. He knows that, and so he doesn't shoot. According to the defendant's testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop and pull the trigger, they get to shoot. But he didn't. Because he was controlled and disciplined. That's the way his career went. And so she steps back, tap, crack, and tries to do it. He doesn't shoot her then. And what's he doing at this point? Kelsey, no. Kelsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kelsey, no. Kelsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day. Tap rack again. Now he knows one's in the chamber. Threat's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would have unloaded her gun. He goes, no, that's not what you do. You shoot until the threat is neutralized. She was now down on the ground. But But his training and experience are still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. He can't see it. Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Noonan is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Hoare comes in and he asks Officer Hoare to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly expected, and that's what he was. He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after? And this just goes to state of mind, I know. That she pointed the gun at me, and it clicked. And she tried to rack him up. Immediately after, this wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the inescapable fact that she is guilty. Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Hoare, even Lauren Page, the mother, even the defendant corroborates what Officer Noonan says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case, and that is guilty. Thank you.
Moving for sidebar.
I'd like to speak with counsel anyway at sidebar for scheduling purposes.
I want to see you talking.
Okay, so we are waiting. They're going to come back on the record. I think notably the Commonwealth did not discuss at all intent. In fact, the charge requires affirmative proof of intent. So under both theories, assault by means of a dangerous weapon, intent is not an option. So when I don't know if my sound was coming through when he was closing, but I did want to interrupt there briefly just to say, he says, we don't know why. Well, that's the definition of reasonable doubt. So I think he just walked himself into a not guilty. I also found, I'm not sure him picking up that gun, it's a little more theatrical than I think this judge needed. Some people, have some serious apprehension around firearms. I'm not sure what the position on this judge is with firearms, but he didn't need to tap rack that gun 10 times. That was, in my opinion, a little over the top. Also, I think I would have taken a really different strategy on this closing if I was the Commonwealth. I think I would have said that both stories can be true. He did go after Kelsey a lot more than Attorney Bradel went after Officer Noonan, which I think is also going to score points for the defendant. Because really he called her a liar and this and that. She is a woman that was in a mental health crisis. She acknowledged that she made intentional misstatements, and she gave a reason for that. She gave a motive as to why she was doing the things that she was doing. He had no alternative explanation as to those points. I think that he can hold up his officer and also acknowledge what was going on. He fails to discuss and disclose what was happening with respect to her mental state. He doesn't address it at all. In fact, I think the fact that the Commonwealth is not really considering that when she is a law enforcement officer in this moment, she is a law enforcement officer, and they seem to have very little care taking at all for what happened here with her. I mean, she's basically just got off her training. She has her 4-month-old baby. She's been told all these things, and they don't do anything else to try to help her. You know, Officer Noonan doesn't try to lunge and grab the gun. He doesn't say, you know, anything. He just shoots her, which, again, I am not faulting Officer Noonan, because I think Commonwealth is correct when they say if she loaded the chamber, yeah, that's lethal threat. So either he's saving her from shooting herself, or he's saving himself from shooting him. There's, you know, again, I don't think that's the issue. In fact, you don't get the sense that Kelsey is upset at all. I'm just going to change the screen here because we have nothing on the screen there. We don't get the sense at all that Kelsey is upset with Officer Noonan. In fact, you know, Attorney Bradel doesn't go as far as what I say happened, which is the irony here is he might have just saved her life. But he does say in his closing, you know, she's been blessed. She's survived 2 attempts here. One was her own attempt to kill herself, and the second is obviously she survived the gunshot wound fired by Officer Noonan. So the fact that she's alive and able to stand trial for this case in itself is a blessing. And what I hear when he tells the judge that is that she's got a lot of gratitude for that. And so, you know, again, we did not hear any anger from her. We did not hear any sort of, you know, resentment when it came to how Officer Noonan, what he did. But she was very clear. There was zero intent to harm Officer Noonan. And I think what was blatantly missing in the Commonwealth's closing was just that. What's the motive here? Why would she do this? And I think we discussed that earlier in the week, that they just were not able to really show why she would lift a gun to hurt Officer Noonan. So the judge is going to basically have to examine that. In my opinion, the judge has probably already made close to his decision. He wasn't, that I could see, taking very many notes during the closings. That could be he's just listening, just like we were, observing what was going on. But the Commonwealth failed to contradict the cross-exam. I mean, he's got a job to do. He's got his case. He has what he has. I mean, sometimes as lawyers, we have the facts we have. He's making the case he can. He has a job to prosecute. He's been told to prosecute. I'm not sure, who the district attorney is up there in Essex County, but somebody's made the decision they're going to prosecute Kelsey Fitzsimmons. And this prosecutor is doing that. He's choosing, to hit all the science piece and the corroboration as far as Kelsey no, but what he has really not explained is the why, and that's a big piece. So the analogy that I would make is, imagine a prosecutor in a murder trial who stands up and says, we proved the defendant was in the room, we proved there was a weapon, we proved someone died, but we can't tell you why we believe they did it. And the prosecutor loses, not because the jury doesn't care about motive, but because intent is an element of the crime. And so we don't know means we didn't prove it. And he said those words in his closing. I mean, I was a little taken back. I'm not sure, I'm not sure if my audio came through because I was muted during that. But I was taken back that he thought he could say that and the judge wouldn't, raise an eyebrow like, excuse me, you just gave me reasonable doubt here.
Turning to counsel table, I'm just going to, we went to sidebar for 2 reasons. One was Mr. Bradel has a series of objections that he'd like to lodge about the Commonwealth's closing, which I'm going to give you an opportunity to do in open court with the Commonwealth in open court responding. And also, I went over the schedule. So, as I told counsel, my intention is to take as long of a period of time as I need to reach a verdict, provide the court staff and counsel with 30 minutes notice, and come out and announce my verdict. some of my reasoning here in public, and whatever time that works. In other words, if it's during our traditional lunch break, so be it. You folks will have a half-hour notice, which means that you'll be able to go and have coffee or lunch or whatever, as long as you can get back here. All right, so that's how we've worked that out. We also discussed at sidebar the fact that in a jury trial, we never provide the jurors with ammunition and a firearm, even with the trigger lock at the same time. So my intention is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition, and the firearm will come back in chambers with me along with the other exhibits. When and if I need the ammunition, they'll be switched out. All right. Okay. Globally, have I discussed have I said in open court what we discussed?
Yes.
Okay. All right. So, Mr. Brado, I'll hear you on the objections.
So I wanted to just take a quick second before Attorney Bradel goes into the objections. I am guessing he's going to be objecting to the mischaracterization of the evidence. Also, he's going to most likely object to the gun being sort of theatrically thrown around. I'll be curious to see, but he's doing this for the record in case there is a guilty conviction for purposes of an appeal. However, I do think that the Commonwealth, again, really talked himself out of and talked himself into reasonable doubt. So Attorney Bradel's doing this as a precaution, and all the defense attorneys, of course, if they saw something wrong with that closing, would make that objection on the record in order to preserve her rights. So here we go.
So, Judge, traditionally we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side to. So, in open court, I'm happy to do this. Sure. Yep, I'll go back over everything I said at sidebar, Your Honor. Judge, the first objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about. He said that it had to be a scientific certainty that this gun was racked by Kelsey Fitzsimmons. Mischaracterizes the defense position that we're not saying necessarily that it did or didn't happen. We said that Kelsey Fitzsimmons didn't rack the firearm. And we have a completely different version of events. So no one's saying that it didn't happen. We're saying that Kelsey didn't do it. And to characterize it like, that it had to be racked by Kelsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence. The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. It out, prior to pulling the trigger, counsel wrapped the firearm the trigger, and that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's 2 different versions of what folks testified about is fair game. What the issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
We expected to hear that.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding, again.
It's just that when you act out the testimony, you have to do it accurately.
It's a misrepresentation of the evidence, and that's the objection. He's going into it, he's getting some extra argument in there, but the judge is telling him,
Reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on credibility.
And hold on, and whether the North Andover Police Department followed procedure in executing serving this restraining order is not before me. Child custody is not before me. All right, visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time that officer needed? Okay, so all of this is just about.
And I offer it on credibility, though, Your Honor.
Okay.
Also, the Commonwealth said that on the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that somebody, a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here, to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent. And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Except that, Mr. Bradle, she waived her right to remain silent, right? She testified, so.
At the scene, though, Judge.
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene, she didn't say X, Y, Z when she didn't have to say X, Y, Z at the scene. And that's, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out of it. You can't say that especially in her condition, that she didn't say something and therefore she's a liar. She has a right to not say anything. So that's my point on that, Judge. And then the last two more issues, Judge, is that there was a mischaracterization of the evidence where counsel stated that Justin Elaine told the officers in the lobby of the police station that Kelsey will kill someone else. He added that to the statement that you might recall, that he said he wouldn't be surprised if she didn't kill the baby right in front of them. That was the statement. He added in that she would kill someone else, which in this case is a very dangerous mischaracterization, that he's ascribing an intent to my client that she wanted to kill someone else, which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Elaine in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it. And then lastly, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Elaine.
I know he's trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked in the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor. And that's my last point. Thank you.
So, from my perspective, with all due respect to Mr. Bradle, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth closing. So I'll give you a few minutes to rebut these things. Let me say this, though. I don't believe that there was any evidence before me that Miss
Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believe it was part of their state of mind in serving it, but
I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Gradle, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence, this sectioning, alleged sectioning that happened prior to this, there's no evidence of that before me. There's mention of it, and it goes to the office of state of mind. So, and that's all that, in fairness, that's all that you argued, Mr. Cooper. But
I guess what I was getting at is if there was anything
at all that came close, that would have been it. But Mr. Cooper, I'll give you a few minutes for your rebuttal to the rebuttal.
The Commonwealth is allowed to be the last word in the court. And so he characterized Attorney Bradle's objections as a second closing.
I
Respect that, both sides. All right, so at this point, why don't we, I said that I was going to step off for the gathering of the evidence. Let me not do that. I'd like the council to just make sure that all the evidence, the exhibits are in order.
We'll look at both sides. If you folks can take a look at the verdict form as well, I don't know if you already have. It's not complicated, but you want see the verdict form? All right, so why don't you
Okay, so we are going to end our live stream here. That's Officer Noonan. Obviously, he's probably feeling very emotional as well after the closings because this clearly impacted his life. I think Attorney Bradle made those objections. I expected them to be misreps of the evidence. The points were made. I think they were good points. He went deeper. I mean, it's hard not to. We're defense attorneys, and he wants to make sure that this record is protected. And obviously, he feels very strongly about these points. He made those points. But I think what the judge was saying is basically like, let's narrow this issue. These issues should be much more, in a very narrow lane. And I don't have to take into consideration all of this stuff. So, the judge was getting a little combative, not in a negative way, just, I should say not combative, authoritative, and really saying to the attorneys, listen, this is what I'm focusing in on, and this is where I think my job lies. So the closing for the Commonwealth did last a little bit longer than the defense, and then obviously those objections lasted even longer than that. So it was, the closings were centered on two critical issues, motive and intent. And the defense argued that the case fails on both, reframing the narrative away from any intentional harm. And the prosecution, in contrast, was attempting to connect the evidence to a motive, which trying to say that it met the legal standard for reasonable doubt. I don't think the Commonwealth made their case. I will obviously respect Judge Karp's decision. He is the finder of fact here, so he has much more experience and knowledge than I do. But just watching it and reading the evidence the way that we saw it come in, I don't believe the Commonwealth, not only do I not think the Commonwealth made their case, but even with closing, he acknowledged to the judge some reasonable doubt. And so that's what the judge would have to find, is that there is reasonable doubt. So he will be contemplating, reviewing the evidence, taking it back, and coming out with his decision. So I am hopefully going to be able to view it live with you. We'll see how this day turns out. And thank you for watching. And if you want to get notifications or follow and watch our content, please like and subscribe. I appreciate it. Thanks, everyone. Talk to you soon.